Hello and welcome. I'm talking to Dr. Abhishek Singhvi. Now, of course, though you're a very distinguished politician, I really want to talk to you as a constitutional expert and somebody who understands the law. There's a lot that's happening in the law in terms of legislation, in terms of courts, judgments, that ordinary people don't understand. I want to start first with the issue of personal liberty. Now, many of us grew up with the idea that bail was the rule, that jail was the exception, that until you were proven guilty, you were considered innocent, that even if the police arrested you, unless you were going to tamper with evidence or run away, there was no compelling case for locking you up. Yet, time after time, we see the opposite. So, can you just explain it in layman's terms why this is happening?
Well, the frank answer is not easily explainable
Oh, really?
because there is a complete inversion between theory and practice. Number one, it is not so much the laws. There have been exceptions in laws for special situations where you have reversed the burden of proof, made bail more difficult, like, for example, narcotics, etc.
Dowry
But the
was one
real,
of them.
or for variety of
Plenty of,
special
yeah.
cases,
Yeah.
admissibility of a confession is normally not allowed, but in special cases it is, etc., etc. The real problem, and that's the first basic point, is how you apply it, how
Okay.
you think, because no lawmaker can envisage and anticipate every situation. So he makes a textual law.
Right.
When governments which are deviant and mindsets which are deviant start misapplying that, that is the real problem. We are an over legislated, under enforced country in some respects, but in many respects now, unfortunately, and I have no hesitation saying it, I'm not being political. If you see the application of so many laws, the misapplication, I would say, it is distortions and using it to curtail liberty. And more than liberty, I think the first thing is to send a message and create a psychosis of fear. I don't actually take action against you, but I have the residual power to threaten you that I have the power to take action. And that is the problem.
But there is the sense now that the government or any government can lock up anyone, and there are laws like PMLA which can be used against them, and it's almost impossible then to get out. Or even if you get out, you've been in jail for several months. Was that what the law was intended to do?
Unfortunately, the sad truth is that I can cite to you umpteen Supreme Court judgments. Can't count them, countless, which repeat this jail is an exception, bail is the rule, etc. But judges are hesitant. There is an unfortunate fear psychosis. I would even blame the press because today we have lost the ability to be non-conformist. A lot of us, judges, lawyers, administrators, do, say, and act as we think people should want us to.
Yeah.
What will the press say if I gave bail in this case?
Even
He will
judges, you
say,
think, might think like that?
subconscious thinking is that.
Okay.
For example, in the old days, many of the cases you see today would not come to the Supreme Court at all. A bail is a very simple thing. A robust trial judge would hear both sides, not hear endless 5-day, 2-day, 3-day, 5-hour arguments, and then give a bail or not give a bail. Today, legitimately sometimes the judge thinks that if I give bail in a deserving case, I'll be considered to have been bribed or I'll be considered to have been biased. Bail reaching the High Court was the maximum.
Yeah.
Why do you reach the Supreme Court now? This is partly also because you have howling cameras, you have screaming press. I would even blame the Supreme Court.
Okay.
In theory, the Supreme Court has given innumerable judgments, bail versus jail, very clearly in favor of liberty.
And
Theory,
the Chief Justice
rhetoric,
gives many speeches about personal
and
liberty.
every judge does.
Yeah.
Why blame the Chief Justice only? And they mean it and they feel it. But you take an individual case where the High Court grants bail. I will not name a current case going on where I don't want to take name of sub judice cases. Or the trial court grants bail.
Okay.
The Supreme Court frequently reverses it or frequently stays it. Now that sends a message. I believe that the consistency is the most important thing. You cannot give a few, points or lectures here and there and then not be consistent. You have a consistent ethic of saying, normally the test for bail is very simple. It's a triple test. Are you a flight risk? That is now gone almost because I can keep your passport. There is no question of any flight risk. Will you interfere with witnesses? It's a very rare situation. It can be monitored completely. Will you not cooperate? I call you 10 times in 3 months. Will you come? That's easily monitorable. Now you come to the special statutes. In the special statutes also, the idea is not to keep you in jail as an under trial without conviction endlessly. Today we have, and I don't want to sound technical, but it's a cocktail of all this together. Today, on the plea of investigation, you have first FIR, you're not named, second, first charge sheet, second charge sheet, supplementary charge sheet number 7, supplementary charge sheet number 9, and you are endlessly investigating. While I'm endlessly investigating you, you are in jail. It is only the courts who have to step
let me
in.
give you a hypothetical example because I don't want you to comment on cases. Assuming there's a person who is a politician, assuming that members of his government are being investigated in what is being described as a scam, you know that this politician is the ultimate target. The investigations continue for several months. His name does not appear on early charge sheets. It then begins to appear. Then he is arrested. The evidence against him is mainly in the form of statements by approvers. They then keep him in jail saying that we need to investigate and he may interfere. But he's been out for like 8 or 9 months while you were allegedly investigating. So if he didn't investigate then, how it didn't interfere then, how will he interfere with the investigation now? What's the logic?
Let's not fudge it. I'll take the name because my submissions can be easily told before your camera. The judgment is the court's prerogative. I'm telling you the submission in an actual case. Take the Kejriwal case.
All right.
The dates are striking.
Who might actually be very similar to the hypothetical politician I described. Yes.
People are amazed, and ultimately it's for the courts to decide. I'm not prejudging the court, but this is my submission officially on record.
Yeah.
Just take 4 or 5 simple facts. 2022, the liquor scam starts. Till 23, there is nothing about Kejriwal.
Right.
In 23, he is called by the CBI, gives a statement. From 23 to March 24, he is not arrested. 2 years have gone. Which interference can he do? Which flight risk can he be? Which document? 10,000 documents all recorded. What can he do? Now, this is point number 1. And he is arrested after the model code of conduct in his case. Point number 2. 4 people, I'll not name the Reddys and father and son and all that. Principal 4 people statements.
Yeah.
Many of them give 8 statements, not naming him. Some specifically of those 8 statements exculpating him. 2 of them say, I came and met Vir. I met him for XYZ, nothing to do with this. And in the 9th statement, he inculpates. Before that inculpation, his son is under arrest.
Yeah.
The son's wife tries to commit suicide. The ED opposes that son's bail. Ultimately, the father sings like a canary. This is on like 2 years later or 1.5 years later. One Sarath Reddy gives 8 statements, and the 9th statement he inculpates. Then there's a third aspect. Many of the statements where he has said nothing about Kejriwal are not relied upon by the ED. They call them unrelied documents. They rely on the selectivity.
What does that even mean?
This is silly. I mean, everything is ultimately in the trial going to come. But they say, for the time being for arrest, we rely on documents X, Y, and Z selectively. And they do not furnish the unrelied documents. It takes weeks for us to get it out of court. Now, this is not the basis of a criminal justice system. What you're doing is you have a fear that you are not going to be able to have evidence to convict you. So the punishment is the process.
Yeah.
The ultimate punishment will not happen. Let's punish him now. And this is making a mockery, and I can tell you that court's robust, consistent interference in 5 cases will change the ambience. Take a simple example. I won the Bansal case.
Which was the Bansal case?
Bansal case is one company, it's M3M, etc. Prior to that, zealously and jealously, the ED would not give you grounds of arrest. I will come and arrest you. I will have grounds of arrest.
But I won't tell you.
But I will not give you the paper.
Okay.
Now, we read 19 to argue. I argued that case, that you have to furnish the grounds of arrest. They said, we have read it out to him, we have told him, as you're getting the card, we told him, but we will not give it to him. The court held that. Supreme Court ultimately, and many high courts were holding to the contrary. The Supreme Court corrected that ridiculous anomaly. From next day, they started furnishing to everyone. But before that, many people had languished because if you don't know the grounds of arrest in writing, you can't instruct your lawyers.
Yeah.
The lawyers can't make out a case. Now you have copious grounds of arrest coming after the judgment. So these are not the way criminal laws were intended to be applied. And after all, there have been special exceptional provisions. Other governments have been there. BJP governments have been there. Narcotics has been there always. Terrorism has been there. BJP, Janta governments, apart from Congress governments, have not misused them, have not. It is happening for the first time. People tell you that very few percentage of cases are political. That's absolutely correct. But do they tell you another statistic?
Which
If
is?
the percentage of political cases is 2% or 4%, which is small, 95 of them are against opponents out of 100. That is the relevant statistic. It's not that it's 4% because most are against businessmen. But all the cases against politicians, 95% are against the political opponents.
Yeah.
And that's why this is happening. Will you ever have in the other cases a Sarath Reddy speaking on 9 statements and then giving this thing? So this is a tragedy.
But a couple of things. One, intuitively, I think anybody watching this will see that there are obvious injustices in the system. Why have the courts not corrected this?
2 or 3 answers. One, there is a general fear psychosis. And that fear psychosis and the generality of it permeates the bureaucracy, the judiciary, the civil society. You and I know, even in our drawing rooms, we look over our shoulders before we speak. That's point one. Point two, the few times the judges walk the last mile, they are unfortunately stayed or reversed by superior courts. So they say, why should we take this effort? Third and most importantly, ultimately many judges get it right in the Supreme Court also. But then the process is the punishment by them.
Yeah, but
In
by
all
the
these
time a
cases,
case gets to the Supreme Court,
that's the process.
Yeah.
That's the many times I as the arresting officer know I'm making an illegal arrest. But I know that after 2 months we will get bail. Let him suffer for 2 months.
Yeah.
2 months is good enough for him to suffer. 3 months is good enough. And you are forced to go up the ladder. In all these cases I'm doing, the Supreme Court frequently says, you may have a good case, go down to the trial court first. Trial court takes 2 months to decide. Go to the High Court, takes another 2 months.
I see that, but some of these cases, at least to layperson, seem intuitively to be obvious. Shah Rukh Khan's son, which was a narcotics case, the allegation was a friend was carrying cannabis and that may have been meant for him. And beyond that, there appeared to be no proof. He spent, 20 days in jail. They had to go to the High Court. The High Court took many days to decide and finally gave him bail. Eventually, the Narcotics Bureau dropped the case because there was nothing in it. But why should somebody be put through this when there is clearly no fault of this?
I think it's extraordinarily lucky.
Lucky.
You're talking 20 days.
It could have been longer.
In most cases we are doing, it is 1 year, 6 months, 9 months. He's extraordinarily lucky. But imagine the same person, you would have found that officer whose name we all know fixed you. Suppose you had found it after 20 months.
He would have
It's
stayed
easily possible. At least 10 months he would have stayed. So this is where robust, strong judging, and let me tell you, we have very strong, good, robust judges. They have to exert
So why aren't they
themselves.
doing anything is the obvious question.
There is another problem here. They are doing it in many cases. But in the controversial cases, in the political cases, in the high profile cases, somehow they are doing it, not doing it at all, or doing it too late. In the average case where there is anonymity is a big cloak.
Yeah.
They are doing it. But where there is this kind of a thing, they are not sending that message sufficiently, or they are sending it late.
So let me give you the other argument, which is the argument the government's defenders often use, that a lot of these cases are PMLA, Prevention of Money Laundering Act cases, which is why the enforcement directorate is dragged into anything and everything, and money laundering is loosely defined. That yes, you're presumed guilty till you actually prove yourself innocent effectively. Yes, bail is a problem, but look, this is not our law. This is the Congress law. The Congress passed it. Is that true?
That's a real fallacy, and it's a very misleading statement.
Explain that.
The act was passed during Congress regime. In fact, the draft of the act was made even before the Vajpayee regime. It was then passed formally, and everybody knows that the Congress enacted the PMLA because we had international treaty commitments. That is not the issue at all. Please ask, and by the way, there's a very important matter pending on this issue. Please ask what are the most draconian provisions we are talking about. All of them, or at least not all, 90% of them, have been passed in 2016, 2018 and 2019. That's in the act. That's been argued by me in the Vijay Madan Lal Chaudhary so-called case. So the amendments which really made it worse, that's one. But it is not really the text of the law. In the same text of the law, Justice Rohinton Nariman's bench in Nikesh Tarachand Shah read 45 very simply and said 45 doesn't mean that you can deny bail. But unfortunately, a larger bench of the Supreme Court in a so-called Vijay Madan Lal Chaudhary reversed it, or rather diluted. Now, that matter of 3 judges is under consideration of the Supreme Court by a larger bench. According to me, it's a wrong judgment. It will alleviate and mitigate many of the bad features, but the Supreme Court is not getting time to hear it.
But tell me this. I mean, again,
you need to hear these matters quickly.
Obviously, Judge. As the Chief Justice himself said in the Arnab Goswami case, personal liberty is the most important thing. Nobody should stay in jail a day longer than necessary. And in the case of Arnab Goswami, justice was done. But when you hear the Chief Justice, you hear many of the judges of the Supreme Court, real intellectual giants, men of integrity, talking about liberal principles. There's such a dichotomy between what they say and what the lower courts are doing. How do you explain this?
See, first of all, of course, extrajudicial announcements or speeches or addresses uh, are ultimately clothed in generality. They are not dealing with the individual
Yes.
case. So
But the
you can
principles
afford
are
to
their
be
principles, right?
principles are clear. You can adhere to principles. The application of the principle in a particular case tests them. As I said, it is in the lower courts at least clearly a certain degree of a fear psychosis. And you have seen those instances. Let's be also very clear. Let's not beat around the bush. There have been cases of delayed appointments,
Yeah.
transfers, blocking you. Ultimately, there's not much jurisdiction which the government has, but they have one very big power. They have the power of delay.
Yeah.
The ultimate power of appointing me or not rests with you. But here, the person has power of delay outside. And that is known to judges. Most people say that, look, we are decent, law-abiding people. Why should we take this harassment on us? In the Supreme Court level, the problem is different. Supreme Court is an apex court.
Right.
There is definitely the power to do good immediately and faster. But it's got 35 judges. It can't handle the numbers coming up. It's got different rosters, different benches. Bench inconsistency is a major malaise and scourge of the system. I had joked once that we have like 16 courtrooms. Perhaps we have even 20 Supreme Courts in 16 courtrooms. That's not a good thing. You have to be consistent. We know today, unfortunately, that I know the verdict largely depending on the bench it is coming before.
That's what I was going to ask you.
That's
That
unfortunate.
has that always been the case?
No,
you can say it's going before such and such bench, so we know what the verdict will be. But has that always been true, or is that true now?
It has never been true to this degree.
Yeah.
Never. B, yes, you do always have had the thing that you have a general philosophy. So Veer is a person with a broad centrist philosophy.
But
That
like
is not
in
what I'm grudging.
America, you have conservative judges and liberal
Not
judges.
only America. America is elections
Yeah.
of judges and political appointment. But even in India, you appreciate the fact that he has Krishna Iyer, for example. Would anybody allege anything against Krishna Iyer? He had a certain bent of mind, but he was a judge, and nobody could even think of something. That is not the institutional, mental, psychological bias I'm talking about at all. But when those proclivities carry on to, a hanging judge,
Yeah.
a judge who will always have a particular view on liberty, then it becomes a problem.
But now, let's be honest, we talk about pro-government judges and independent judges. Has that always been the case?
It has been to some degree, to a far lesser degree. But I think the degree has increased. The degree has increased because progressively over the decades we've been making poorer and poorer appointments.
Yeah.
What happens when I propose your name? Ultimately, you will get through if the collegium, which is the final power, sticks with you. But in the process of delaying you, they will bargain for two not so good judges to also get through. Who will bargain? The government may bargain. Okay, we'll let Veer go through if you let A, B, C also go through. In that process over the years, you never had the top front line of law practitioners joining the bar. But a good second line was there. But if you did go down from second to third line, now possibly functioning in the fourth line, ultimately the Supreme Court will have judges from below. They will have judges from, and that manpower, that skill set, that absolute tensile moral strength and fiber. We know those judges. We know, I can name many of them, as you know the names. That doesn't exist everywhere. Today, let me tell you, we are one of the finest judges in the Supreme Court even today. But then there are the other exceptions also.
But explain this again to me. I can understand a fear psychosis in the lower judiciary because there's a lot of damage the government can do in terms of delaying promotions, whatever. But once you're a Supreme Court judge, you're a Supreme Court judge. Nobody can really touch you. Even the Chief Justice is done by seniority. So why should people not be independent?
No, first and foremost, the degree of that fear psychosis is far, far lesser in the Supreme Court. As I said, in the Supreme Court, the determination of subject matter is within only 2 or 3 benches. So if a particular subject matter falls before a particular judge who falls in that exceptional category of having a mindset, then there's precious little you can do about it. Secondly, matters take a long time to reach the Supreme Court. That's the biggest problem. you are already suffering for 6 months minimum before you reach the Supreme Court, if not 1 year. Thirdly, the material coming to Supreme Court, although still very strong, outstanding exceptions we have, is progressively, I'm talking of a trend, becoming relatively poorer in manpower material. So all these three combine ultimately.
As educated middle class people, we've always said that the one institution of our democracy that works, that keeps us going, is the judiciary. It doesn't matter what happens to politics, it doesn't matter to the executive. Are you saying that there, because of quality of manpower issue, even there we're seeing a progressive deterioration?
There is an interesting paradox there. Today, with everything, the most trusted institution would be, I would not say judiciary generally, but the Supreme Court.
Yes, absolutely.
Supreme Court will not have 1/100th of the trust deficit you find not only in the executive and the legislature, but in every other institution. You can have it in the EC, you can have it in the CAG, you can have it in so many places. So we must cherish that. Secondly, the Supreme Court, by and large, in institutional history, I just gave a lecture at Oxford on this subject, India at 75 and Supreme Court at 75, our constitution. It has had various phases. No doubt the Supreme Court had a emergency phase, which was the Nadir. But then you had a post-emergency quest for legitimation. So you have these phases. But by and large, the Supreme Court remains an institution of faith and trust. It is individual aberrations which create a bad taste. And I think you have to ultimately, we have an outstanding Chief Justice now, intellectually and otherwise. You have to have Chief Justices who can set the pace. They're not merely judges, they are leaders. They have to be an exemplar.
But have you seen with the Chief Justice the kind of abuse he's subjected to on social media on a daily basis?
Now that is the, I'll give you the most outstanding example of this, is the same sex, which I led the arguments on, the same sex thing. I'm not talking of the merits, that is a done and dusted deal now. It's a 3-2 judgment, and the Chief Justice and his colleague judge in a dissent went to the civil union level, but stopped short of the same sex. But Vir, I was of course also subjected to social media calumny, but the kind of memes and the kind of things I got on my phone about the Chief Justice. He's a very liberal, fine person. He is an intellectual giant, so he can take it in stride. But any normal people could be set back by that, could be scared, and families would be traumatized. Now this is something which, and let me tell you, a lot of it was orchestrated. A lot of it was orchestrated, and we can understand where it was orchestrated. So these are things which ultimately only civil society can combat. What else can you do? You can't go and catch these hundreds and thousands of people who are trolling you everywhere.
But civil society would stand up more for the judiciary if the judiciary did more to stand up for itself, if it stood up for civil liberties, for the individual much more than it does.
The judiciary does it in the anonymous cases, but when they stand
but
up
not in the
high profile ones, they send a message to civil society. That is where more needs to be done. That is where the judiciary can send a message that we are here when push comes to shove. That is the time when civil society looks up. And there is a feeling of vindication. So
and that hasn't happened, no? The judiciary in the current situation, when people look to it, it hasn't stood up for itself.
It has stood up many times, even against big adversities, but over the general period of these 2 or 3 terms of this government, I think that has been a failure.
I think there's no getting around that. Before we move on to the new penal code, now there one last thing. People say about the UAPA that again, lots of people who didn't deserve to be in jail were kept in jail for a long time on evidence that was flimsy or non-existent. Yes, they say, but it was Mr. Chidambaram's law. It's the Congress that passed the law. Do you want to explain that?
I think there is a broad national unity on a specific central code law only for terrorism or anti-terrorism. I think on that the national consensus cannot be diluted. It has been pre-TADA in different name, TADA and onwards, UAPA. In fact, UAPA is supposed to be a slightly better version of TADA. The problem again here is how you apply it. You are now distorting it for cases of big dissenters who are not terrorists. It's as simple as that. That's where this problem is there. And that is ultimately a question of applicability and operational, not of the law. Today, you know that dissenters, whether in the guise of sedition or non-sedition laws, there are a lot of crazy loonies out there whom I defend, whom I don't share their views. I don't agree with their views about Marxism.
But that's the
But
point
that
of a free
doesn't mean
society, no?
that that person's view makes him a terrorist. He subscribes very strongly to a particular Marxist view, and other people who subscribe to the view may be terrorists,
Yeah.
but he doesn't become a terrorist by that. This is the problem with UAPA today, much more than the text of the law.
Okay,
And
I accept that. But we go back to the old question. If you can see it and I can see it, why can't the judiciary?
No,
Why do so many of these guys spend so long in
no,
jail?
judiciary does interfere where they find in the cases of
People
dissenters
like
where it's been,
Stan Swami, etc. Come on, what
that's
happened was a scandal.
I think there was a very, very inexcusable delay there,
Yeah.
where it was irreversible delay. But I've done many of those cases also, those 6 people. In other cases, they've intervened. But you are right, the draconian nature of the law pushes back.
Yeah.
So I think not enough has been done, but where the courts are making a distinction between terrorist acts, it must be an overt act or not merely thinking or ideology, versus dissent. They are in principle making that distinction. It's taking time to give the relief. And the real thing is, India's judiciary is the high court and the lower courts. That's where the reform has to come. There is no reason why I have to travel to the Supreme Court for a bail where I will possibly get it with greater likelihood.
Eventually. Yeah.
The problem is that this is an overloading of the apex court.
Okay. Now let's move on to the new laws that were passed changing the old penal code. It's been hailed by the government and its supporters as a way of getting rid of old colonial laws, having laws that reflect the new India. I know that when the laws were passed, you were in Parliament, and if I'm not wrong, you were supposed to speak on behalf of the United Opposition, but they short-circuited that process by, I think, expelling or suspending 145 people or some huge number of MPs. So I don't know if you ever got to make that speech. What would you have said if you'd made it?
I was the lead speaker
Okay.
for that, the opening speaker. And since 142 of my colleagues were there, the entire opposition took the stand that we will not participate. So obviously, I could not be the lead speaker. I then satisfied myself by writing an article of what I was going to say, partly, and I've written another one in the near future. But that is, by the way, I think it is much more important that a matter like this deserves the widest, highest, most broad-breast plenary consultation. If you are passing laws which are supposed to be so important, as the government says, not me. Yeah. I don't consider that the changes they made are very significant. But then all the more reason. Did you have a law commission? Tell me, Vir, how many such fundamental laws have you changed without a law commission report? Law commission is your statute. Your statute creates a permanent body.
Yeah.
In the old days in the England, it used to be called Royal Commission. It's very important. No. You have a small body of 3 or 4 people, most of whom are non-practitioners, doing this. The range of consultations with civil society was minimal. But forget all that. Today I have written now, and it should be coming out soon in the near future, that if you had humility, which I think you don't have, I think it's never going to happen, but if you had a certain, feeling of lack of infallibility, then you could easily, by way of an amendment, reconsider the laws in Parliament tomorrow. How do you decide when 142 of the opposition is not participating? The answer given is, you didn't participate, you could have. If you suspend 142, the others can participate. Theoretically, you are right. That is what some people of the government are saying. But it's ridiculous to say that why can't you have a rediscussion? But you have to have humility for that. Secondly, I think, unfortunately, vanity and cosmeticism are the hallmarks of these laws. I did a survey. The essential changes are only 8 additions, 22 repeals.
Okay.
Balance, about 34% of the entire IPC, I'm talking about only IPC, is changed.
IPC is Indian Penal Code.
Indian Penal Code. 34% is changed. But all the other changes other than 8 additions and 22 repeals are very minor facial changes. So what substantive are the big changes are 2 to 3%.
So what are the big ones?
Well, big ones, I will say the only few good ones are that there is a reformative element added, community services added, less penal. But there are far too many bad ones, negative ones.
Such as?
Sedition, no less than the Attorney General, and I happened to be in court, gave an assurance to the court that we'll keep it in abeyance, we'll reconsider. Obviously, he didn't commit anything. It was kept in abeyance for 2 long years, no prosecution of sedition went on. You have a reincarnation to Deshtroh, treason, of that provision with enhanced penalties. It is actually a left-handed compliment you are given to Macaulay, whom you are trying to bury. Yeah. It is Macauleyan concepts, which you are reincarnating with more enhanced penalties. So, all right, I call sedition treason, you call treason sedition. But that is clearly retrograde. Then also, Where are the structural changes? The entire government is going around talking of fundamental structural. I am all for it. The 2 or 3 structural changes I would like are not there. One, have a division, a Chinese wall between prosecution and investigation. This is the biggest problem of our criminal system with the lowest conviction rates. You are the IO. Do you know how it actually works? You are the police inspector. The whole morning you spend in going investigation. After you land up in a court, evening you sit and decide whether to prosecute. Then you go and give evidence. There is no Chinese wall between the prosecution. The district attorney in America is a very good example, but that is too far. Even in England, you have a Chinese wall. The Department of Prosecution decides, the investigator comes and puts the material.
And the investigator has to persuade the CPS.
Objectivity, transparency, independence. No change. There are Prakash committee report, there are Supreme Court 10 judgments. If you really had to crumble, you should have done that. Then again, I would have liked ad hoc experimentation in criminal law with people like recorders. In England, senior advocates or advocates are put in charge for 1 or 2 years for petty criminal offences. You know how many traffic and other petty offences clog our criminal system? Yeah. They dispose of hundreds. Try that here. You don't have any of that. You have made, basically, it is to, I mean, I don't want to sound flippant, but it is the criminal law counterpart of the Central Vista. You want to leave your stamp. Yeah. In your stamp, I'm welcoming it. Please leave your stamp. But in the process of doing so, make structural changes. You have not made structural changes. You should have increased the list of compoundable offences. Compoundable
for
means,
the benefit of the...
Compoundable means that you, if I hit you and there's an offence, there should be an option to compound it in money terms and the offence goes away. Yeah. You can have more reformative, not that I jail you for everything, have community service. These are, progressive, avant-garde, futuristic changes. Very few. 1 or 2 are good. I told you 1 or 2 community policing is good, but very few. And the worst part is that you have been anti-libertarian.
In what way?
Very important is remand. The Honorable Home Minister did give an answer which seems plausible. You see, when you remand, you have to finish everything within 15 days under the current law, the pre-existing law. Now, the remand can't exceed more than 15 days before the charge sheet is filed, etc. Now you have said the total period will remain that, but it can be over a period of 40 to 60 days.
I don't understand. How can it be
that
15
in bits and pieces? So I can take your remand for 2 days now in this week, then I don't need you. Then again I can come for a remand after 1 week. Then again within an overall period of 60 days, this is the new law. Now the total period I can keep you behind is 15 only, but it can be in bits and pieces. So the Honorable Home Minister says we have not changed actually the totality, the aggregate. But the point is you're having a Damocles sword over him hanging over 60 days, longer period. And in the longer period of 60 days, it is more discouraging for any judge to give you bail. Because even after the first 5 days, when you say, I don't need him now, I'll need him after 10 days, the idea of giving bail between that time is highly unlikely. So these are negative changes, and I don't see the point of all this. You are just, playing around with this. I think this is more some degree of vanity. We must leave our own name, our own stamp. And there is one other thing which I must tell you, Vir, which has not been thought about. In fact, nobody has mentioned it. I mentioned it in my first article. By making facial and slight changes, which are minor, comma, full stop, one word here and there, you've not made any significant change in those 34% of the provisions.
Right.
But what has happened? There is a corpus of 150 years of judgments on the old provisions, which have settled the law. So by now every judge knows the law is clear, because not the text of the law, but the judgment has settled it. Now by a slight change, what you are doing is you are enabling a accused or the prosecutor to argue the whole thing again, saying reinvent the wheel, the law has changed.
There are no precedents.
No precedents. Actually, there is a precedent. Ultimately, judge will come back to the same conclusion, but you will increase arrears. There are 50 million arrears at the High Court level, of which 50 to 60% are criminal cases. When you reinvent the wheel, when you have established precedent which you ignore and re-hear the matter, you're taking more time, you're going to increase arrears. So vanity.
Everything you say is clear and it explains things, but it's also very depressing. So where is the reason for hope?
Well, this particular one I think was unnecessary. Either you had to do it, you had to have the structural changes I've called for.
Otherwise, but they haven't done that, they're not going to do it.
This is something which is now brute majority. Yeah. What do? Brute majority goes through, so it is depressing, but you have to live with it and you see what best. Some things are good, like video recording is good, but these are procedural things. You can't call it a structural change.
But the general principle, what we've been talking about, some of this is procedural, but a lot of it is a mentality. The mentality is that the power of the state will far outweigh any rights to liberty that the individual may have. That's a trend that's actually increased in the last 10 years. Do you see it getting worse?
Well, there is no doubt that there has been over the last 10, 11, 12 years a attempt to make it more and more a presidential form. Now, a
Yeah.
presidential form of governance is not necessarily authoritarian, but it is coupled with clearly the tools of governance being micromanagement, control freakism, and fear. Now, that can be done by a variety of means. It is by appointing pliable officers in bureaucracies.
Yeah.
It is by getting your things done through those officers. It is by doing micromanagement wherever there is an opponent. You must track him, you must watch him. This is, you don't need statistical studies for this. Everybody who's in India knows that. It is not a criticism of India. It's a hearkening to the strengthening or the re-strengthening of Indian democracy. We are an argumentative nation. We do not have this culture.
Assuming, and now it's a possibility, till about a year ago, I would have said wasn't even a possibility that the opposition, the people you represent, comes to power. Would you like them to look at all these things again?
Many of them, of course, absolutely. I don't think, I mean, you know it well, uh, for all their pluses and minuses, the Congress governments were heavily criticized by those who suppose are supporters of the Congress.
Yeah.
So a certain liberal ethic is part of democracy. We didn't come at your gullet because you were criticizing us. And I can tell you that any journalist who puts his hand on his heart can say that, forget Congress governments, Vajpayee government,
Yeah.
the degree of criticism, the degree of scrutiny. Today you have to think. Even I will be surprised, think before I tweet,
Even you.
which is very surprising. I never thought of it like that. Not that I think too much, but then, it just strikes me that this will be now called seditious. I have given many lectures on Indian democracy at 75, India at 2047. And I start by saying that, look, these are all by a former parliamentarian, by somebody the good of the nation at heart. But tomorrow, if somebody accuses me of sedition and criticizing India on a foreign soil, please protect me.
True.
So, this is a thought process which is very bad. I don't think it should be there.
I don't know whether the changed circumstances in Parliament, the numbers having changed, will make a difference. But otherwise, I think we're looking at least another 4.5 years more of this.
It should, but ultimately the impulse will have to be political. Unfortunately, this government understands only one thing: numbers. There are sufficient numbers in non-BJP groups within the NDA which can send a message on the extremities and the boundaries of distortion. They can say these 1, 2, 3 things don't do, cannot do. Whether they put their foot down on bulldozer Raj, whether they put their foot down on arresting you from Gujarat for a tweet and taking you to Assam jail, whether they put their foot down, that's their choice. I hope and trust that persons of that ilk will make that choice sometime. Now, when they do it, are political decisions, but that is the one lesson which this government understands.
Yeah.
Otherwise, any amount of opposition is doing it every day. We are shouting and we are doing this, but
they
that
don't
is
care.
not.
They don't
that-
really
they don't
care.
care.
Yeah. So I think fairly depressing in terms of what we're talking about. The answer, I think, lies in political dispensations, in people within the government, or at least the government coalition speaking up, in the judiciary standing up more
Absolutely.
for individual rights, and for civil society being aware of what's being done to our liberties.
Absolutely. Absolutely. I think a combination of these will make a difference, even in a small part. It changes the atmospherics and the thinking process and the ambience, and that is important.
Okay, let's hope so. Abhishek Singhvi, thank you so much.
Thank you.